Good afternoon. My name is David Godfrey, and I'm Director of the ABA Commission on Law and Aging. It's our pleasure to release the full report of our research into the experience of persons living with dementia and the criminal legal system. The report has been posted at americanbar.org/aging. The views expressed in the report and those in this briefing today are of the commission members and the members of the research team. They've not been approved by the ABA House of Delegates or the ABA Board of Governors and do not represent the position of the ABA or the institutions that the research team are employed by. I want to thank the RRF Foundation for Aging for making this project possible. I want to thank our incredible research team and the supporters that worked with us on this project. They're all listed in the report, and every one of them made a real difference in pulling together a really, really meaningful project. Also want to thank the over 300 professionals who volunteered and provided input in our research process for the surveys and the interviews that we did. We chose this issue because there hasn't been a systematic effort to understand the impact of neurocognitive decline, commonly known as dementia, in criminal prosecution and corrections. And with an aging population and increased number of persons in correctional settings, these issues are critically important. The project included a review of peer-reviewed journal articles related to this topic, review of case law, primarily appeals case law related to the topic, an examination of data from a state Alzheimer's registry and corrections records, a survey that received over 300 detailed responses from professionals in this field. The responses, single-spaced, were over 60 pages. I read every one of them. And interviews with 45 professionals in this field. The report contains the results of this process. The analysis and editing on the data and the report continued until this time yesterday. And the report is really the first step in creating change and improving the system and improving the lives of persons living with dementia. Joining me today are Professor Richard Bonney of the University of Virginia School of Law, Dr. Jennifer Bronson of the National Association of Mental Health State Program Directors Research Institute. She gets the award for the longest employer title. Dr. Deborah Penals from the University of Michigan, and Serena Worthington from the RRF Foundation. Richard?
Well, thank you, David. My job is to give you a little overview of the report. So let me start with some numbers. An estimated 6.2 million Americans age 65 and older currently have dementia, and that number is projected to increase to 12.7 million by 2050. As the US population ages and rates of dementia increase, the prevalence of dementia among persons involved in the criminal legal system can also be expected to increase. Indeed, these demographic trends have already had a marked effect on the prison population. The number of state prisoners 55 and older increased by 400% from 1993 to 2013, a 20-year period. And experts predict that by 2030, less than a decade from now, this older age group will account for 1/3 of the US prison population. It is also important to emphasize that this aging of the prison population is attributable to two factors, not only the demographic direction of the country, but in addition to the aging of the US population, it is also attributable to the continuing effects of the nationwide stiffening of criminal sentencing that occurred in the 1990s, and particularly the use of quite lengthy mandatory terms of imprisonment for a wide range of offenses. The impact of these two trends is already becoming evident, but we still lack systematic information and data which impedes the development and implementation of necessary and proper responses. A priority recommendation of this study is that we need to develop and implement an efficient method for dementia screening in jails and prisons across the nation, and for accompanying metrics regarding the effects of pertinent policies and interventions. Policy responses are needed at every stage of the criminal process. This comprehensive approach, which is taken in the report, mirrors the initiatives that have been so successful in improving the criminal justice responses to individuals with serious mental illness over the last couple of decades. The report recommends many action items for local and state agencies, and I will highlight a few of them here as a foundation for more specific comments that Jennifer Bronson and Deborah Peinels will provide on a couple of these matters. First, we need system-wide training for case identification and response for all criminal justice personnel, including law enforcement, attorneys and judges, and particularly for the personnel associated with correctional agencies, both state and local. As with mental illness and developmental disorders, diverting persons with neurocognitive disorders from the criminal process requires access to clinically indicated placements and supports in the community, whether the charges are dropped or even if the person remains under criminal justice supervision. These placements do not now exist in most communities. Third, a key priority for prisons and jails is to provide therapeutically appropriate and protective conditions and programming for inmates with dementia. And Jennifer Bronson will discuss this important topic in her comments. Fourth, when consistent with public safety, people with dementia should be transferred out of the traditional correctional system altogether. Fifth, many pages of our report are directed at a common pathway for defendants with dementia in the pretrial process. Courts or attorneys raise questions about the defendant's competence to stand trial, competence to provide assistance to the attorney and understand the charges. And the defendants are referred for assessment, typically to a state forensic hospital, where they are often found incompetent to stand trial. The court then commits the defendant to the hospital for restoration of competence, which is not likely to occur given the nature of the disorder. As Dr. Peinels will explain, this pointless practice should be ended in favor of a more appropriate placement and perhaps a new legal procedure. And finally, we need a new legal mechanism for placement and protection for a subset of aging people with neurocognitive disorders, dementia, of course, being the main, who pose danger to themselves or others, and for whom traditional residential arrangements and family-centered legal protections are not adequate or available. We need a new civil legal mechanism, as well as safe placements for these individuals. And this topic merits a follow-up study and perhaps a multidisciplinary working group to think about the development of such an alternative. It would be one mechanism for dealing with people who are found incompetent to stand trial and thought to be a threat to public safety, and often are now just held indeterminately in the forensic system. So that is my overview and identifying some of the particular recommendations that we've made, and I will turn the baton, so to speak, back over either to our chair or perhaps to Jennifer Bronson, whoever picks it up.
Jennifer, go right ahead.
Okay. Hi, everybody. I have one summary slide to share. Okay. I'm going to briefly discuss dementia among people in correctional facilities, jails, and prisons. The incarceration of people with dementia generally follows one of two pathways. The first, an older adult with symptoms of neurocognitive decline, is a first-time arrestee in their 70s or 80s. The second, a person develops dementia during the course of serving their sentence or aging behind bars. The first group you'll find more in jails and the latter in prisons. And this is important because jails and prisons hold different populations, and this impacts the way the facilities are able to organize and deliver healthcare and programming, with prisons typically having more ability to provide those resources than jails. In almost all cases, incarceration is not the right placement for people with dementia, and we heard this from all of our correctional-based respondents. Individuals with dementia often have complex health conditions and have high service needs. They are also at significant risk for victimization from their peers and staff, injuries from falls, declining physical and emotional well-being, and for placements in restrictive housing units. People with dementia are often unable to understand, remember, or follow rules, and non-compliance with correctional rules and directions is often treated as a disciplinary issue rather than a medical issue. Furthermore, symptoms of dementia often go unnoticed by the individual themselves, meaning they are unable to advocate for themselves, to receive healthcare and supports. This is something we heard in our interviews, that often it was actually a peer that would first notice that something was wrong with, quote, POPs or GRAMPs, and then bring it to the attention of correctional staff. Very few, if any, correctional settings can provide dementia-focused resources. This is difficult on the outside, so it's even more difficult on the inside to provide the resources to meet the safety and care needs of these people. Moreover, the punitive and rehabilitative goals of criminal justice are unattainable in the case of people with dementia. When release is not possible, state prison systems, large jails, or regional clusters should consider the following recommendations. 1, designate specialized long-term care nursing units and a centrally located facility that can house and care for aging inmates with complex health needs. 2, establish a facility-based geriatric care team or a key facility person who can provide legal advocacy and manage the care of people with dementia. An existing model is in place at Rikers. Institute, quote, dementia-friendly environmental design elements, particularly those that are relatively quick and inexpensive to do, such as adding more and clear signage, improving lighting, different paint colors, handrails, moving dementia patients to lower bunks, and then giving them more time to respond to commands, drills, and stimuli. Utilize peer support programs to positively support the person with dementia, such as California's Gold Coats program, which trains volunteer peers to help the person with dementia navigate daily activities, provide protection, and facilitate social integration. 5, institute routine dementia screenings for people in prison starting at age 50 or 55 and older. This is because dementia in correctional cities often co-occurs with significant mental illness, substance use disorders, and/or brain injuries that can advance aging. Ideally, though, we want these folks diverted from prison and jails. To facilitate that, standards and processes for medical release, conditional release, and compassionate release should expressly include dementia as a qualifying condition. However, efforts to use medical parole or compassionate release often encounter difficulties with securing a placement when the release is approved. So you'll have instances where everybody's on board, everything's been signed, but there's nowhere in the community that will accept that person with dementia, and they wind up in the facility still. Recommendations to improve community-based placements include the development of public-private partnerships to develop and fund care placements for people with dementia and a criminal history. Establish community-based safe care placements for people living with dementia and who have a history of violence. Evaluate and amend laws and policies that prohibit placement in otherwise appropriate care settings. So oftentimes a person with a felony or misdemeanor are prohibited from being placed in a particular nursing home or memory care unit. And lastly, develop a civil path for diversion. And I am going to turn it over to Deborah Pinels. Thank you, everyone.
Thank you so much for those remarks. And thank you to my colleagues who were instrumental in getting this work done, and especially to the Retirement Research Foundation and the ABA for hosting this event and funding this work. And I'm doing the yeoman's work of lifting this report to its completion, and to my colleagues at University of Virginia as well. I just want to comment and follow up on what Richard and Jennifer talked about. You heard about the risk of people with dementia, neurocognitive conditions being arrested and then routed through what's called the competency system, having been identified as perhaps not being able to assist in their own defense, and then being found incompetent to stand trial or unable to aid and assist. And then very often they are sent to state hospitals. In our conversations, there were many people who felt that the state hospitals, would be the place to care for them. But as somebody who's worked in state hospitals for many years, these hospitals have been really focused on treating serious and persistent mental illness, individuals with those types of conditions. And of course, we do have people in state hospitals who are aging and need to serve those that are aging. But in order to get some of the same environmental changes and programming support for people who have dementia, the state hospitals currently do not have the resources or perhaps even the expertise at times to do that. And so we really do need to identify different programs and placements for these individuals. Restoration services themselves traditionally involve legal education. And as Richard pointed out, there really is not a value in spending time providing legal education to somebody whose condition is only going to be declining and not likely to be restored. The medications that are used to treat psychosis, for example, would also not have the impact for somebody with a co-occurring dementia, if they are also psychotic, on treating the conditions that's rendering them unable to aid and assist in their own defense. The important issues also involve this idea of civil commitment that can otherwise be used for people with mental illness. Many state statutes exclude dementia from civil commitment provisions, and that further creates a barrier to getting people into care, even when the crime for which they were arrested was one that involved a high-risk activity. And so our mechanisms really don't take this condition into account, and our laws don't either. Again, with the guilt phase and punishment and mitigation and sentencing that might be possible, also doesn't take into account the neurocognitive decline that these individuals have been demonstrating. And what I want to add to the conversation, which is also embedded in our report, is something that American jurisprudence has been paying a lot of attention to, which is the jurisprudence of neurodevelopmental conditions. We have come to appreciate that the young brain and youth are not just small adults with adult brains. What we have come to appreciate is that youth have different brains that are developing and emerging and becoming to a place where they will turn into adults. And so the judgments that they display are not going to be the same as something that a person with a mature brain will display. And to that end, even the United States Supreme Court has recognized that neurodevelopmental factors need to be considered in major laws that we have adopted. So for example, juvenile life without parole sentences have been completely re-examined by the US Supreme Court. Findings that it is unconstitutional to execute somebody that committed a dangerous murder offense as a juvenile has also been overturned. And so in recognizing the importance of brain function in jurisprudence, I think what this report really does is allow for a clarion call to our advocacy community, to our legal community, to anyone who will listen, that we really need to rethink the jurisprudence of the neurocognitive disorders and related conditions, and take into account the aging brain and the deteriorating functions that people may exhibit, and really look at issues related to criminal processing, culpability, competency, and those types of laws that put people with dementia at risk for being treated in a way that is not well serving to society as a whole. Any one of us would want this for our loved ones and ourselves. And as Richard said, it does not mean we need to compromise public safety. We need to recognize that there may be issues that need to be addressed from a safety perspective, but that is compassionate. I became interested in this early on in my career when I was consulted on a matter of a man who had engaged after many, many years of wonderful marriage, had engaged in a violent offense towards his wife. He was immediately swept up into the forensic process. He was never allowed to see his wife again, who really wanted to see him. She survived the incident. He had a serious dementia that had not been identified, and he ended up dying in a state hospital, separated from his wife forever. It was a tragedy. It was not the way it should have gone. There could have been things in place to support him safely and support the wife so that her functioning could also be upheld after so many years of a wonderful marriage. So advocacy should also center around this. It should center around identifying a pathway toward criminal processes that factor in dementia and reduce the potential for findings of guilt and assist in creating a safe off-ramp from trial processes. And with that, I will conclude and turn this over, I believe, to Serena.
Hi, everybody. Thank you to our excellent speakers and to all of you for joining us today. I'm Serena Worthington, and I'm a program officer at RF Foundation for Aging. Our Board of Trustees supported this project because it's groundbreaking work to address a neglected but growing problem, as we learned today. The report establishes an important baseline knowledge and understanding of the scope of the problem and identifies potential policy reform areas. Recognizing that the systems change anticipated by this project requires a long-term horizon, the real impact of this initiative will be realized as the suggested policies and practices are adopted by organizations and professional groups. We know that legislation and changes to standards of practice will come through the persistence over time. However, today, we are taking a collective step towards justice and compassion for older adults with dementia who interact with the criminal justice system. On behalf of RF Foundation for Aging, I extend thanks to these project leads and the many people involved, and a special thanks to Charlie Sabatino, who initiated this project prior to retirement. Thank you, and I'll turn things back over to David.
Thank you. The report is just the beginning, the start of a lot of work that needs to be done to change the way this is considered, looked at, changes in law and policy and practice. Please read the report, share it with your friends. We're available to help with training or education support, presentations and such. You can connect with us by emailing me, david.godfrey, Godfrey, @americanbar.org. We need those that are listening to help us be the agents of change, and the change is going to need to take place in each and every state across the country. I thank the team for everything that we did on this, and our speakers today and our audience for joining us. Thank you very much.